My bad, y'all. I done been out of whack for so long. I done forgot how to use this stuff. All right, y'all. So listen, I hadn't recorded this video already, so I done watched this already. Okay. Somehow, after a whole hour of recording it, reacting to it, guess what happened? It's no audio on it. So I'm like, before I even go through the hoops, I'm just gonna go live and do it, okay? Because it's part of the YNW Melly um hearings and stuff. So yeah, so y'all, I 40 minutes. I don't watch this. Now I gotta watch it again. But welcome, Truth Team, y'all. We're gonna get this out the way because you know I try anytime we have something that. Hold on, what's this? Man, hold on, y'all. All right, y'all. I'm kind of today back in the office a little bit. Okay, we back, we back. All right, so if y'all don't know, YNW Melly trial got pushed back. Okay, what's up, DT? Got pushed back due to the fact they're waiting for the appellate court, okay, to make a ruling on the affidavits, right? The affidavits, y'all may be like, so what you mean the affidavits? Well, the affidavits on the search warrants for early on in investigation, okay? And remember, Judge Murphy took a bunch of the pieces out, narrowing the time frame, all that. This happened about 2 years ago. Remember when Bradley left off the case, the new prosecution came in and they're like, no, we need more time. We need evidence in, blah, blah, blah. Okay, so that's a quick recap. Like I said, y'all only have an hour or so, and this is like 40 minutes. Okay, Chelsea, what's up? So we're gonna get into it. I don't know why. Y'all make sure y'all let me know if y'all can hear it. Cause I don't know why the volume was messed up, okay, when I first did the reaction to it. So we're gonna go ahead and get started. We're gonna hear oral arguments in the appeals court, okay, in regards to why the affidavits in their entirety should be in as far as the state is concerned, and why they should remain out like Judge Murphy decided for the defense. Okay, so let's get into it. I'm gonna skip past it till they actually start. Not go to. All right, we at the beginning. Y'all, let me know if y'all can hear the sound. It's a little low, but just let me know. So y'all don't hear it? Nobody hears it? What the world? What is going on then? Yeah, I'm so over this. I'm about to just quit for the month because what the world? Because I can hear it fine. Hold on. Wonder why, like, what's the problem? Wonder what's going on with that. All right, y'all. Give me a second. Give me a second. I may have to reset my computer. Maybe that's the problem because I don't know what's going on. So hold on. Give me a second. Because I don't want to get 40 minutes in. Because like I said, I done already did this reaction as a video. All right. Hold on, y'all. 1 second. All right, y'all. I'm about to reset my computer real quick because, like, I don't know. That's the only thing I can think of right now. Okay, I don't know why I'm having audio issues right now, y'all. Like, I don't know what's going on. So bear with me for a moment. Let me get this back. Because, boy, I was so mad, y'all. I hadn't did the whole reaction. 45 minutes. Just to find out it was no sound. And I was like, what the word? And it's only the parts of the court. So I'm gonna see if resetting my computer, helps. We gonna see. But just give me a minute. Welcome everybody over. All right, hold on. It just reset. Let me see. Let me log back in. I don't know what's going on. Cause last night it worked just fine. So I don't know. Pretty Z, what's up? So like I said, y'all, the hearing was like 40 minutes, so we're not gonna be all day. But like I said, I wanted to make sure we had this on in our archives. So hold on, let me switch back to the computer. All right, let's try this again, okay? Brandy, what's up? Let's try this again. Hopefully we make some progress. So hold on. Let's try this again. All right, y'all let me know y'all can hear the court. Can y'all hear? I don't know what's going on. All right, we can't do it. Yeah. I don't know what's going on. I don't know why the audio. Let me see if it's just that video. Well, this might be a shorter live than I thought, y'all, because let me try this.
Everybody back? All right. Okay. Everyone's back. I hope you enjoy your lunch. We are ready to go.
State Paul's Rebecca Morano.
All right, so it must just be how they got theirs, and maybe it's just how that channel is. Because I can hear it. Like, just on there. Yeah. And then the bad part, this is the video we need for the live because this is the Melly one. So give me a second. Let me see. Dang. I really want to shoot. Alright, I'm at the T-Dub. Please, I don't want to block nobody today. Okay. I ain't got the energy for the craziness. I'm pausing it because I want to. Okay, first and foremost. Let's just start with that. Like, why ask me why I'm pausing it? Please don't get blocked today. Please. Okay. I'm here for a brief time to do something, but I ain't got the willpower right now, okay? Hold on, let me see if I can get it something on. No, they keep saying go to YouTube. It's not here. Yeah, please. I'm trying to look. I want to start the live, but right now we're having technical difficulties, okay? But yes, give me a second. I'm trying to figure it out. To see why we can't hear it. Okay. Fourth district. Fourth district. Oh, they haven't put it on there yet. Yeah. We might have to wait. I might have to just do it tomorrow. Because why can't we hear it? Okay, hold on. Let me see. Why can't we hear it? So they haven't put it on. Let me show y'all what I'm looking at. They haven't put it on his case yet for me just to click on yet. So that's the problem that we're having right now, because y'all see it still say schedule, even though, again, because I done watched it already. So even though it done happened, it's been over for a few hours, it's not available on there yet. But and I wonder if it's because they technically took the live down. The live not even on here no more. But I guess it's still on my end because I never closed it out. I ain't get. Alright, I'm gonna try to play it one more time to see if we can audio. If not, we're gonna have to just reschedule this live for another time when we can actually hear. Can y'all still not hear it? Let me know. Can y'all still not hear it? Yeah, ain't. Yeah. And I don't even think I'm gonna be able to pull it up on my I'm trying to think of a loophole, y'all, so that we can get it done while I'm on live right now. Maybe. All right. Maybe what I'll do All right, let's try something. Let's just try it. We here. Let's just try it real quick. I'm going to see if I can come through on my phone and play it, and we can hear it that way. We're going to try it at this point. So hold on. Let me mute this one so that we don't hear that static. All right, let's see. All right, y'all let me know y'all can hear it through the phone. I know y'all can't see me, but y'all let me know if y'all can hear it. Let me make sure. Ah, shit, this ain't gonna work either because it's gonna be that sound. Hold on. God damn it. Is it gonna still static? Yeah. Hold on. All right. Let me see something. Let me know if y'all can hear it now. I had to take my other thing off the screen. Let me know if y'all can hear it. Ooh, my foot going to sleep. Can y'all hear them talking? All right, y'all want to rock out like this? All right. We just going to rock out like this so that we can go ahead and get it. I was trying to let y'all... You said barely? Okay. They ain't really talking right now. I'm just playing part of it. Trying to see if we can get the audio. All right, so hold on. Let me get to where they really talking. Y'all let me know y'all can hear it good. Oh, shit. All right, we're going to rock out like this, y'all, because this is the only way I can think to do it.
Welcome to this session, oral argument for the 4th District Court of Appeal. Judge Gerber and I are very pleased to have with us this morning County Court Judge Sarah Shulman. Welcome to the court, Judge Shulman. We have 3 cases set for oral argument this morning. The first case is the State of Florida versus Jamel Demons. Jamel Demons. Thank you, Ms. Howard. You're not used to sitting in that chair. I mean, so are you ready to proceed, counsel?
Yes, sir.
Okay, please step up.
Good morning. May it please the court, Senior Assistant Attorney General Yesenia Concepcion on behalf of the state, and I'd like to reserve 5 minutes for rebuttal, if I might.
Okay, sounds good.
And I'll focus my comments on standing and independent source. As to standing, before invoking the Fourth Amendment's protections, a defendant must establish standing, showing that he has a legitimate expectation of privacy in the area to be searched or item seized. And at his first trial, the defendant disavowed ownership of the phone, which included the iCloud account, social media, sort of those attendant sources. And the lower court, which had presided over the first trial in these proceedings, agreed that the defendant had, quote, was basically saying it wasn't his phone. And so, despite never having affirmatively claimed ownership, the trial court here found that because he disavowed it once, but didn't disavow it again, that was tantamount to claiming ownership and a privacy interest in the phone. That's simply not what the law requires. So in this case, the defendant never made that initial showing of establishing ownership and his expectation of privacy. And so that's sufficient for this court to reverse the grant of the suppression motions on that basis alone.
Did he take the stand at trial and testify that that wasn't his phone?
That was just the theory, was that the state had not proved that the phone and the social media accounts were.
It was the position that the lawyer took the different lawyers, of course, but right? What didn't he get?
I don't know if it was the same or a different counsel. Okay. I'm not sure. I don't want to.
That's what they said. The lawyers said in the first. Okay.
That was their theory. It's not his phone. You haven't proved it's his phone. So certainly he didn't claim ownership of the phone to establish standing. And the same here. He never claimed ownership of the phone. And the court, instead of saying you've shown, your ownership interest, your privacy interest, said, well, you haven't not shown. So that was the crux of the error, basically. And so as to independent source, the purpose of that exception is to leave the police, state investigators in the same position, but not a worse position, if there had been no error with the warrants at all. So here there are several independent sources, which left investigators with all the same puzzle pieces that they would have had, even if the court, years after the execution of most of these warrants, wouldn't have found that it needed to have a narrower temporal scope. So not that the warrants themselves were bad, but that the time period was too broad. So the strongest, and there's several, and I'm not going to recount my briefs as the court has reviewed them, but the strongest sources were the victim Anthony Williams' phone, which contained not only the cell site evidence, which showed that they were traveling together and then weren't at the same time that Mr. Damon's phone was moving in the same way, but showed the communications between them that were ultimately suppressed when they suppressed the iCloud results that showed that they were longtime friends, that they were having a dispute over money, over the direction of their rap group collective. Those same messages would have been found and were found independent of Mr. Damon's phone. The same with public social media posts regarding gang activity, regarding...
one of the problems that it would seem to me the state has on here is that it really relied on Detective Polo's testimony to develop the independent source, inevitable discovery issues. And Detective Polo came into this case at least 4 years after the shootings. And with the benefit of 20/20 hindsight was going back and sort of looking at it. And it seems to me he was saying what he would have done had he been on the case. But, couldn't the judge reject, or don't we have to assume that the judge rejected Detective Polo's recreation of that and deciding that inevitable discovery and independent source were not appropriate? He could have rejected Polo's testimony because it was after the fact and wasn't even involved in the case at the time.
Independent source specifically looks at either before or after the initial search at issue. So it just has to be independent. And Polo came on board, I believe, when the superseding indictment was filed, which added the gang enhancement. And so it now became even more relevant to get this information, the gang-related information. And when we look at what he looked at, everything that he looked at was available or would have been available to Moretti when he did his first 13 warrants, the ones that are at issue here. So he's looking at publicly available social media posts. He's looking at those communications in the phone extractions that we already have from either the co-defendant or the victim's phones, and looking within Moretti's, applying the temporal restriction that the judge imposed, from there was able to get all the same information. So independent source is not defeated by the fact that his investigation came after, merely that it's independent. And it obviously was independent, right? Because he's looking at a slightly different angle, because he is concerned and his expertise is the gang involvement. And he's also involved in the tampering case, looking at what he was doing in terms of tampering with witnesses. So the fact that we have those independent sources and that Polo is independent of Moretti, I would say helps the state's case. And the case law is clear that the independent source can come after as long as it's independent.
You use the word would. He would have had that information available to him. But isn't that easy to say in hindsight? And how do you distinguish between every case in which, sure, in hindsight, vision is 20/20. Mm-hmm. So looking back on it, Detective Moretti can say, sure, I would have done this and I would have done that. But what framework are you suggesting for, if this were to apply to every warrant, if the state were to always say, well, we would have found it through an independent source, now knowing what we know? Why don't you look back to what they knew then and what they actually did then or would have done without having the benefit of hindsight? See what I'm saying? What framework do you suggest for every warrant?
Well, and I think in this case, it's crucial that the investigators had all of these pieces already. So they already knew that this was potentially a gang-involved shooting, that Mr. Damon specifically was involved in a specific gang that they name. So they do have all of these pieces, and the warrant that they were traveling under included these communications and in this time. So he did not obtain those warrants because he didn't need them, because he thought he already had the material from these warrants. And we can absolutely see a world in which, you can say, well, I would have done this, and that's not allowed. But here we have very specific testimony where Detective Polo goes piece by piece. This, for example, the Facebook post with the defendant and his co-defendant, and they are wearing shirts that commemorate the victim's death, and they're talking about the victims. That specifically, he says, that would have led me to believe reasonably that they are having communications on Facebook about these murders, and then that would have led me to seek a warrant for these murders. So I think in this case we have a lot of specificity. I'm sure the court is aware that the hearings with Detective Polo were quite long and quite involved. So it was more than mere, we would have done this, we would have done that if we didn't know. These were the investigations he was already doing before the motions to suppress were filed. And I think some of the cases talk about that. When are these independent sources coming up? Is it before or after a motion to suppress is filed and you're scrambling to kind of find something else? That's not the case here. These investigations were ongoing, and he was already pursuing these materials that were publicly available, so therefore an independent source, and already in the state's possession, like the victim's phone, the co-defendant's phone. So there is no sort of benefit to anyone to exclude the things the state already had. And I think that distinguishes this case from others where maybe they don't have that, or they go out to seek it after a motion to suppress has been filed. Have any more questions?
Not at this time. Do you want to save your 5 minutes?
Yes, thank you.
Sounds good. Okay, thank you, Ms. Concepcion.
Good morning, Your Honors. Carrie Howard on behalf of Jamel Devins.
How do you feel about standing? How do you respond to this?
Well, I find it so curious that issue is even raised. Because if we look at the record of the hearing in front of the trial judge, which is why the trial judge did not even address standing, the state specifically said, at one point, I do raise the issue of standing. I'm withdrawing that argument. That was based on misapprehension of the ownership of the devices, and that's just in 10 and 11. And that is on R3347. So I would submit that the trial court did not address standing because the state specifically withdrew that argument in the trial court. And it would be very difficult now to recreate the facts for standing, not for standing, in front of all of you. So I would submit the state has waived that argument, not even waived it, withdrawn it in the trial court. And so it's not an issue. As also argued in the briefs, the affidavits themselves establish standing, as they all allege that the phones are Jamel Demon's, the various social media accounts are Jamel Demon's. So I would submit that the affidavits also support standing. I think this case really presents sort of the classic modern day Fourth Amendment concerns from 1789, right? Where the concern of the government being able to rummage through a person's most personal information and most extensive, frankly, more extensive than what you might be able to have in a home back in the 1700s, has to be limited. It has to be limited by a warrant. It has to be limited by a warrant that has probable cause to believe there's a crime and that particularly describes what is to be searched. Probable cause to find a gun doesn't allow law enforcement to look at a diary just because it may be interesting to know what does the suspect think, do, know, what are their activities, and that's really what most of these affidavits support. And you know, in terms of leaving to the unfettered discretion of law enforcement, the affidavits themselves really lay out that that's what we're asking for. We'll decide what's irrelevant. We want all of this information. We'll go through it and decide if there is information that supports our investigation. So while we do take issue with the trial court's adoption of the severability doctrine, which I'll spend a minute or two at the end talking about, you have to respect the painstaking efforts this trial judge took to consider the lengthy written arguments, read the 13 affidavits and warrants, and listen to 2 days of evidence initially, write an extensive order, the omnibus order, addressing each warrant individually. And they all have different time frames and different matters. The trial judge went through specifically to address what information was sought, what was obtained, and what did the affidavit support. So the trial judge considered the individual circumstances and the probable cause, and then the trial judge allowed essentially a relitigation of issues with inevitable discovery and independent source that should have been raised initially. It is why Judge Murphy's order comes to you with a presumption of correctness as to the determination of the facts. There's quite a bit of argument in the brief as to the appropriateness of even having the rehearing reconsideration hearing that litigated the only issues the state is now arguing, independent source and inevitable discovery. I leave to the court that issue, as you're the purveyors of the rules of procedure, but it appears the state's argument really primarily was raised under the guise of the motion for rehearing and reconsideration, as these doctrines were not even raised initially. So apparently the government accepts the court's ruling regarding the overbreadth of the warrants and relies on independent source and inevitable discovery. The trial judge did not find much value in the independent source, and it appears that the state's argument is that not that the evidence, which is all of the evidence that was subpoenaed, right, all of the phone records, all of the social media, not that that evidence would have been that there was an independent source for, but that there was an independent source for another warrant for those items. And I would submit that is not the purpose of the independent source doctrine, that the purpose of the independent source doctrine is really, I think maybe this court in Carter addressed it, where the evidence of I think it was Carter, the tag, yes, there was evidence obtained from a driver's license, but the tag was totally independent from the driver's license. And that evidence was obtained at the same time and was used to connect the suspect to the crimes. So, independent source, the trial judge found the state was sort of conflating the two. I will admit the case law is at times sort of mixed. I believe what the U.S. Supreme Court has said is that inevitable discovery is sort of a part of independent source. But essentially the government argues that Polo's investigation 4 years later into gang activity would have uncovered the same information if he had obtained a warrant supported by probable cause and with particularity. Since that was never done, we don't know if that would have occurred.
Aren't most of the independent source cases and inevitable discovery cases, don't they, it seems to me that they involve like the police officer goes and runs into a house on exigent circumstances, but the police are already in the process of getting the warrant. So the warrant, that whole process is in place, and the judge, it's easy to look at and say that, oh yeah, they would have found that. Isn't this kind of a unique application of that?
I would say yes, it is a very unique application. What we do know from the cases that address, and as I say, some of it is interchangeable, but independent, inevitable discovery, like Rodriguez, that there has to be a showing that investigation was already underway. So the warrant they were already going for, even though there was an illegal entry into the home, and the warrant was obtained without any of the information from the illegal entry. And, the Supreme Court in Rodriguez, this court in Roll, has always said you have to show that the investigation was being actively pursued at the time. So what we have is Polo's investigation 4 years later, not actively being pursued at the same time that Moretti is pursuing the warrants and obtaining all of the information that he did. So I think it's very distinguishable. It also is, I was thinking about this. It's the retrospective analysis. Detective Polo didn't just look at the publicly available information to come up with his opinions. He had already reviewed, and this is in the record, all of the data that had been obtained pursuant to the warrants that the trial court had then ultimately ruled had to be temporally limited. He then went back to the information and superimposed the temporal limits that the court ruled on, and then said, based on those temporal limits and all, I could have done this, or I would have done this. It's so much speculation, it's so much hindsight, and frankly, it's, and I don't mean to impugn Detective Polo in any way, but we have to assume he put out of his mind all of the illegally obtained information that he already had reviewed. And I just don't think the courts are expected to do that, especially with an investigation 4 years later on a separate topic. And what the trial court was concerned about is that Polo's investigation was really about the gang enhancement that is alleged in the 2023 charges. And Detective Polo says even he would have limited his warrants to information related to the gang investigation. So then we have two separate things that we're even investigating. And what evidence would have been relevant to the homicide versus the gang investigation? I think this is why the courts do say you have to show you're actively pursuing the same information at the same time as you obtain it unlawfully. And I think that the trial court really, patiently listened to another day of testimony from Detective Polo, overruled for purposes of the hearing repeated objections to speculation, right? Because Detective Polo routinely said, well, I woulda, or I coulda, or I shoulda. And the defense objected to speculation. Trial judge said, yes, it's speculation, but I'll allow it for this hearing. But in conclusion, he ruled it was all speculation. That Detective Polo's testimony was based solely on speculation that he would have done these things. We might be in a different posture had there actually been, at the same time, warrants issued for the gang investigation, and we could compare, was there an independent source? Would it have been inevitably discovered? But instead, we're going 4 years later and looking back on it.
So I need to move you along. Let me just have you address, one other thing.
Yes.
So we get off this. I don't mean to interrupt you, but didn't the trial court save the state's bacon by narrowing the temporal application of the
Yes.
of the thing? And why you need to address why that's not, why that was error, or
Okay.
why we shouldn't do that.
And thank you for, I'm not so good with clocks. So the temporal severability issue is a novel issue in Florida. The trial court cited a footnote in an older case. Severability has been used in other contexts, like legislative enactments, things of that nature. But in terms of in Florida on warrants, it has not been used. And I would submit for policy reasons, right? Because it really would encourage law enforcement to just go get everything and then let the trial court make the decision. Well, now we know this is relevant or this part is appropriate, rather than once it's found to be overbroad, the entire warrant should fail. And so I would submit that is a novel issue in Florida. The federal courts have addressed it and have addressed it in various ways and with various limitations. And I'd finally note the trial court did note on the severability issue that you should weigh how much information was obtained lawfully within his, the time limits that were imposed versus unlawfully. And there's really nothing in the record that tells us what that is, but I would point to specifically.
But here's, in doing
Yes.
that analysis, let me just interrupt you. He's, what he wanted the warrant for was to pin down the location of the defendant. And so it seems to me that in the drop of all the evidence, that all the location testimony is going to be, that's relevant, is around the time of the shooting. And the stuff that goes back to, October 1st, that's really not relevant to the location at the time of the shooting. So in weighing the testimony, why couldn't the trial judge have decided that this was the relevant evidence, this is what they were looking for, and that, that this serves the proper purpose?
So I would have a hard time disagreeing with you if it was just the day of or the day after, but there are a number of these warrants that stretch and the trial court ends up allowing for a couple of months. And I would submit that those, I know on the motion to suppress number 11, which might be Gmail's, I have to look at my notes, the court said the vast amount of data obtained compared to what would be relevant, but there's really is not, appropriate, but then he does limit it, but to like a 2 or 3 month period. And I would submit that there should have been a specific weighing. Was there much more data gathered illegally than what was important for and supported by probable cause? That's the standard that has been accepted by several of the federal courts and that the trial court cited, but that analysis is not contained.
Okay, my last question, I get that, I understand your answer. My last question is this. I mean, look, you talked about the policy that, would be implicit with this. And this is a quote from, because I had to read all these federal cases to prepare for this, because there's not much in Florida. But the Fourth Circuit in U.S. versus Zelaya Velez said that courts, this is a quote, courts should not punish law enforcement officers who are on the frontiers of new technology simply because they are at the beginning of a learning curve and have not yet been apprised of the preferences of courts on novel questions. I mean, doesn't that make sense to you that we should be more forgiving of courts and law enforcement at the beginning of this frontier, which really starts with California versus Riley versus California, when they said this applies to cell phone, and now we're in the area of social media.
So yes, except I would say by 2018, there were some cases with regards to this, and some of the later warrants weren't until, I think, 2020. So, we should learn and we should grow. And I think law enforcement, given their enormous power, should be charged with the responsibility of keeping up with some of those areas of law. My time is up. Thank you very much.
So I'd like to clarify the standing issue.
Yeah, let me just give you focus. You've got 8 minutes, okay? Because I let Ms. Howard go over, so you get the same amount of time. Let me just add. Let's move away from standing, okay, to really the heart of the case, if you mind. I mean, that's really, I think, what I'd like to focus on. The Supreme Court in 1920s decided Olmstead versus the United States, which applied to a wiretap off-site of bootleggers who were operating a business in a townhouse, and then we come up years and years later, and we're now in social media and cell phones in Riley versus California. And the problem that I'm having with these warrants is that initially they were so broad. I mean, that I was surprised that the trial judges signed these warrants for the time frames when they were really trying to get the location. And it seems to me that that law enforcement needs to take the bull by the horns initially and narrow the search, because that's the way search and seizure laws developed up until this moment in time. In this case, why didn't the trial court save the state's bacon, as I asked Ms. Howard, by narrowing the temporal time of the warrants? Because these warrants there's no way a month before anything in any of the information would have helped their initial detective locate the defendant at the time at or around the shooting. I mean, you just can't make that argument.
Well, I think when we look at especially in those initial warrants, what Moretti is looking at, so it's not only his location, it's location, and then there's a progression in the warrant applications. And first it's, this vehicle has shown up and people are dead, what's going on? And so this is all you know. So you're like, okay, well, let's look at the phones of the people in the car, their locations. And then you get to location, you get to Mr. Damon's phone, and then you see that he is communicating constantly from lead up to the murders, to the execution of the murders, and thereafter. But
why shouldn't courts require law enforcement to start narrowly, around the time, use information that it obtains to go back and get warrants later that broaden the scope of what the law enforcement is allowed to search?
Well, I think when you read the warrants together, I do think that's what's happened here. We started small, and then with more information, it's like, okay, now we have cell site information, so we know where you were. And then we find Mr. Withers, for example, who's talking to Mr. Damon's on Snapchat, and we know he's communicating through Snapchat.
But the initial evidence drop, was was huge. I mean, and didn't the first detective have to go through, hundreds of thousands of pages of
Well, and I think
data, like to really find out what was relevant?
Right, and I think that's the nature of the way they receive this evidence. So another thing that we haven't addressed, but another job of the state is to identify the owner of the accounts, the phone, and you need, I think they call it, I don't know if proof of life is the right turn of phrase, but so you need some space outside. We're not talking about a year before. This is like 3 weeks before the crime, and the phone itself, the iCloud account, only existed since August. So this is really a case where you cannot possibly say, well, we're going to get your entire life forever and ever.
But the point, if I understand Judge Gross's question correctly, is even the 3 weeks was arbitrary. The trial judge's determination that there was no relationship provided as to why that 3 weeks point was just, well, let's just go back a certain amount of time. And there's no probable cause for that.
And I think that's where it was to establish the identity and the owner of the phone. I believe that was the basis that Meridian, I don't remember if Polo also said that, but I believe that's what Moretti testified to. And so you also have the officer testified, I also believe it was Moretti, that the way they receive this, it's not sorted for you by, let's say, Apple, and you say, well, only give me this evidence of the crime. They just don't have the capacity to do that.
But couldn't law enforcement be required, let's say with Apple, for example, they've got some pretty smart people working at Apple. Couldn't they give them certain language parameters, like certain keywords, and have them, I don't know, I don't do this, but have them conduct a search in that way, subject matter, narrow the parameter of the search? Because there's temporal, but couldn't they, if they gave it to Apple, couldn't Apple search according to those language parameters?
The testimony was that they could not, that they didn't have the capacity to
But that
sort.
came from the cop. That came from the
And there's nothing to contradict that,
well, I mean,
right?
it would be different if it were somebody from Apple. I mean, right?
And the defendant certainly had the opportunity to present that argument or evidence, but the only evidence we have, the uncontroverted evidence we have from the testimony of Moretti, is that it cannot be sorted in this way. And
Couldn't the judge kind of assumed that we generally all know now that cell phones track your location. I mean, that didn't need to be proved. And I mean, wouldn't it be similarly
I don't think so.
assumed that, like, Apple could track could conduct a search based on narrower search parameters set up by law enforcement?
I don't believe it's the same. We don't use that technology the same way we use, if I have Google on my phone and I'm using Google Maps to navigate to the courthouse, I understand that information is saved in Google. I have no idea how Apple, and I'm not very techy, so maybe that's why, but I have no idea how Apple stores, keeps, sorts, tags their information. And so I don't think that that's within the common knowledge of, a judge issuing a warrant. It is within our common knowledge. I think most of us use the GPS on our phone now, so I think that's within the common knowledge, but I wouldn't say how a software company keeps and tags its information would be commensurate with that.
But going forward, don't you think that, like that quote from Salaev Esquiza, those are the types of things that law enforcement should become cognizant of in obtaining warrants?
I don't know how.
Because, when you do a wire, just a wiretap from the old school stuff. I mean, there were very narrow parameters that were allowed on the wire. You couldn't listen to every call.
Right, but I
the
think
concern here is that the police are looking at everything that's dropped on the cell phone,
and I think in the wiretap, the police are in control of when they're listening and how they're listening. The police are not in control of how Apple keeps its records and how they provide them.
But they didn't try, right? He didn't try. It's not that Apple told him no. It's that Apple can't do it. But there was no evidence that they requested either a temporal limitation or search terms, and Apple turned them down. And I think the point is that as we move forward, why aren't these things that law enforcement should be trying while trying to balance the Fourth Amendment protections? And I'm left wondering why they needed the entirety of these social media accounts to identify the owner, or proof of life, as you said. I mean, that could be very narrowly tailored. In fact, they said they were going to have a tank team. So the detective clearly knew that this was fairly broad and he was asking for a lot. So he recognized that we're going to have a tank team, but then that never happened. They just got access to everything and went through everything and decided what was going to be relevant and what wasn't. So how do you justify searching the entirety of somebody's social media account for something as narrow as identity?
Well, and I think we have to go back with what we have in this record, and it was the Moretti's testimony that in his experience, they don't have the capacity to sort, and so we have nothing to say that they do, right? So I think there's just no way to do anything other than take that as this experienced officer's experience in obtaining warrants. And in terms of the social media accounts, they were tailored because I think the focus was communications. What are you posting about? What are you commenting on? And who are you talking to? Because we have probable cause to believe that you are having conversations about not only committing the murders, so the premeditated design to commit the murders, the accomplishing of the committing the murders, and then covering up the murders after the fact. So in this case, it's not just a broad, well, who is it? It's like, we know, and the warrants go through, this is the specific trail I'm following, and I have probable cause to believe that they're having these communications on these platforms with this person and what they're talking about. And so I don't have the same reading that it's this broad, anything and everything you've ever posted on social media or anything you've ever said on social media. It was focused. The earliest was October 1st, was like the earliest date that was requested, which is a few weeks before the murder. And like I said, I think in this case, the independent source is so strong because we have complete untainted communications sitting there in these devices that were not obtained through these warrants that Mr. James would have no standing to contest, and they contain the same information that is the definition of an independent source. And so there is just no benefit to anyone, to society or investigators, to suppress when the evidence is literally sitting in the exact same phones that are already in police custody. Can I just very quickly make the point about the standing, that the withdrawal as to the standing, contesting the standing was only as to suppression 10, which is the physical device of the phone, and that's because there was confusion with the whatever the number of the phone was. But you can see in the motions for reconsideration, specifically standing was contested on all the relevant motions that we are contesting. So that we ask that you reverse. Thank you, Your Honors.
Okay, thank you, folks. We'll take this under advisement. Counsel, very well argued by both sides.
All right, y'all. Give me 1 second. I'm switch back to the regular computer. Hold on. All right, y'all. So thank y'all for bearing with me during these technical difficulties. Okay, they do have visual for it. However, we couldn't get it pulled up. They have since deleted the live. Luckily, I never took it down, so that's why I was able to still play it. So we figured out we had to bootleg it a little bit. Okay, but just a quick rewind. So this is about all of the affidavits for warrants that Judge Murphy threw out, right? Remember, he said, hey, it was too broad, okay? Y'all want all this stuff from up here and all that. He narrowed it down. We went over that breakdown, I think, on live when it first happened. I have yet to find the live. We might do it again, but this is important. And I will say this, because the last part that the prosecution was saying, if you have all these independent sources, okay, that basically have this information, why are you going so hard to keep the affidavits in or keep the information? Because if your independent sources, Polo, Moretti, if they found all this information, regardless, if you got this phone, all this information in one of the victim's phone, then why are you going so hard, meaning pushing trials back and stuff, going to the Supreme Court over it? I told y'all from the start, I felt like the new prosecutor, I can't remember her name, that took Bradley's spot. When Judge Murphy denied her motion for more time because she was new to the case, I felt like she took this to the Supreme Court, the appellate court, because she wanted more time. I don't think it has nothing to do with the search warrants needing to be saved, because as they just said, they already have these details per other things that Melly can't contest. I think it was all employed by time. I've been saying it, and I'm really locked into that the conclusion now after hearing that. Because why go through all this if you can still Buckaloo, boom, that's her name. Okay, so I felt like this was the only legal way to get more time after Murphy, okay, denied her motion for more time. Okay, so I just think this is a ploy, because if you got all this independent information, now, me personally, I do agree with the defense where they said, like, it's easy to say, oh, yeah, we could have got to this point by ourselves without the search warrant. Yeah, now that you got the search warrant, because we all know, okay, this case was built on moving backwards. Everything from the beginning, everything was moving backwards. I'm pretty sure Polo took what they already had and went from there and built from that. So the foundation of it all is built off of these search warrant affidavits, for sure. There's no way in my mind you're going to say, prove otherwise. Now, will the judges, and I'm like, we can't hear the audio, obviously, but I'm going to just go back a little bit so y'all can just watch the judges. I'll be honest, the judges at no time showed us any type of anything on their faces, okay? So I can't tell you which way they was leaning. They had good questions for both sides as they did their arguments. So I can't tell you where they're going to lean to. I personally, if I was up there just, with what I know and what I heard, I would keep Judge Murphy's ruling as is, especially since the state has already said, well, we have all this without the search warrants. We got to these conclusions without all that. Well, what you here for? You don't need to be here. That's just me. That's just how I feel about it. So yes. So for those who were not here from the beginning, I will clip it down and put it on my page as a video. I do apologize for the hiccups earlier, because like I said, this is my second time listening to it, okay? Because the first time I did a reaction for a video and it was no sound. So that's it. The prosecutor for the case, I believe they saying went on maternity leave. I don't really keep up with her, so I don't know if she had a baby or not. I just know from day one, I've been telling y'all she's gonna get that time one way or the other, okay? One way or the other. Dre said the girl is the glue. Once that boy contacted her when he got out on bail, it's why it's tempering. Now they're gonna use her to take the stand. Say yes, she saw the dead bodies. Melly was on the phone. She never told them she saw no dead bodies, though, Dre, okay? All she will say is that she got a face, if it gets to that point, right? And if what she said was true, she will say she was on FaceTime with Melly while he was in the woods, and he told her they got in the shootout. Melly never admitted, and this is based off the case information, Melly never admitted to, what's the girlfriend name? Mariah Hamilton, that he did anything. He just admitted that, again, they got into a drive-by. Now listen, why will that hurt Melly is because Melly whole defense is he never made it to wherever the shooting. He got out the car. So that would be damaging, right? If she gets on there and said, well, I was on a FaceTime with him. He was in the woods waiting to be picked up, and said that, the two victims was dead. Okay. But he never admitted to her about being a part of it at all. All right. So, and that came out in court. Remember, her original police statement was showed at the first trial, where we could read for ourselves, and I did a video on it, where she never said that Melly said he did anything. He just admitted that something had happened to them, basically putting himself there. So that's that. It's kind of like, again, he got new lawyers, so I don't know what the strategy will be this go around. Hopefully they don't take too long, to come back with a decision, because maybe the trial can move up to 2026 instead of 2027. I will say this: a few of y'all have been hitting me up with links to the victim's dad page. For those who have been around during my Melly coverage, y'all know that man don't fool with me and I don't fool with him. Okay, I would never run with none of his information, whether it's right, wrong, or whatever. He do his thing, I do my thing, and it is what it is. Okay, so as far as whatever he is putting out in the atmosphere for about Bortlen, hey, it is what it is. Once it hit the courts on record or in a document, I'll go over it. But y'all, please, please. I'm dealing with a lot right now, and like stuff like that just irritates me. Okay, because y'all know when I don't fool with a creator, I don't fool with the creator, even their content. So y'all, please stop sending me that man link. Okay, if he's whatever he's saying, and y'all enjoy the content on his end, go watch his videos or whatever. I don't fool with that man. I'm not going off of nothing he said. Okay, so again, that's all I ask. Appreciate the T-Dub. That's all I ask y'all, because I'm just getting too many messages with them links. And this is just not for his links. Y'all know I don't like when y'all send me links at all, because I don't watch other videos, especially about stuff I'm covering, because it will cloud you, right? So again, that's it. Jerry said Bortlen took the plea because he knew that girl gonna take the stand. I think it ain't had nothing to do with it. I think Bortlen took the plea because it was his best bet. Like, it was his best bet. Y'all got to think about it. Melly already been sitting there for all these years. He basically almost did a decade almost, right? Like, you facing 5 life sentences. You're not going to get on the stand and testify in your own defense. Why would you take it to trial? Like, it just didn't make sense. Don't be surprised if they warm out a deal with her and she takes the stand. Well, she has to take the stand. She's a witness. She don't need a deal because they're not accusing her of doing anything. So she's on the ankle monitor until YNW Melly goes to trial for the second time. Mariah Hamilton is on the ankle monitor. She has to testify. They doing her like they did her mom the first go around. So it's not a matter of working a deal. She's going to get on the stand regardless. Now, what she's going to say, I don't know. Like I said, at the end of the day, he never admitted to doing anything to her. It's just the fact that she could confirm the FaceTime call that they don't have the record of. She can confirm what he said to her directly because she was a part of the conversation. Remember when her mom took the stand, she was a third party to the conversation. But if Mariah testifies, she actually was the one allegedly on the FaceTime. Okay, so it's one of those things we got to wait. You know what I'm saying? You think we get a appeal result before 2026? I think so. I don't think it will take that long. It could now. It could. But I think, yeah, definitely before 2026. Anything else, y'all? This is just, again, remember, this is what was holding up the trial this go around. This is why the trial possibly is pushed back to 2027. This is why. So now that it's out the way, it's just a matter of when the decision will come down. Matter of fact, while I'm on this live, even though it wasn't part of it, let me just do it out where I'll clip it down later, because I had a few people about the Lil Durk situation. Dang it. Who sent me? Somebody sent me that. Hold on. Give me a second, y'all. Let me find it. Here we go. Shout out to the Twitter community, okay? Thank you, Paradise. I really appreciate it. It's been rough. I've been trying my best, though, to like get back to content for sure. But yeah, it's definitely been rough. So I do appreciate it. Thank everybody that's been in the comments in regards to the loss of my cousin. My cousin was murdered and left out on the side of the road for multiple weeks while we were around here looking, but we When we ultimately found her, she was deceased. So I do appreciate all the support with it because, boy, it's definitely been something. So I appreciate it. Now, I don't know. Let me see if I can blow this up a little bit. It's on Twitter, so what I would say, okay, because y'all might not can't read this too clearly, and it's on Twitter. Let me see. So basically, what this is that stipulations regarding requests for continuance of trial date and findings of excludable time periods pursuant to speedy trial. And it basically says that some people on Dirt's case are wanting to postpone trial from October 14th to January 20th, 2026. Okay. Um, this is a little bigger. So it say number 10, it say defendant Banks does not join in stipulation to continue the trial in this manner. Nonetheless, the stipulating parties agree that pursuant to 18 U.S.C. blase blase, the time period from the date the stipulation is filed to January 20th, 2026, exclusive constitutes a reasonable period of delay for defendant Banks, who is joined for trial with co-defendants as to whom the time for trial has not run and no motion for severance has been granted. And even if Dirt's lawyer, now again, this is just how I feel about it. Even if Dirt's legal team files severance, it will get denied, in my opinion. And the reason why it will get denied is because for them to link it to Dirt, they have to have the story to include everybody else, right? So they have to paint the picture with all of them together. So I feel like the judge, based on the argument from the government, will not sever Dirt. They tried it in the O Block case, it got denied. They're gonna try them all together. And at the end of the day, just like with the YSL case, like regardless if you wanted to speak trial, if you're a code, they're gonna find a legal way that this is gonna be pushed back. Personally, I feel like it definitely need to be pushed back. Now, again, they may not have so much directly on Dirt, but they have a lot on other people. And their teams may not have the top dog lawyers. Their teams may need more time to comb through every piece of evidence because you never know. It may be that one call that you didn't listen to that may be the nail in your coffin, right? So it say number 11, nothing in this stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods to be excluded from the period within which trial must commence. Moreover, the same provision and or other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the periods within which trial must commence. Meaning, hey, until by law we can't get more time because of the speedy trial, then we'll do that. But as of right now, within our guidelines. So my personal view of it is that yes, indeed, the trial will be pushed back. It won't take place next month. That's how I feel about it. We'll find out once a ruling comes out about it. Like I said, I haven't really been keeping up with any content recently. I just happened to see that floating around on the blogs and decided to add it in. I shout out to Bryson Boone Paul because that's how I found out about the oral arguments for Melly this morning. So I'm trying to find my way back to content. It's step by step. Eventually, I will be having to deal with my cousin's funeral. I'm actually getting ready to leave in a few to head to the family house because that's underway. So it's a lot going on. This is about, I will say, this is about the most tragic situation I have endured since being a content creator. It's been kind of hard balancing, dealing with real life and content. It just felt like I just pushed back from content to focus on real life. But I'm trying my best to drop more content, and that's where we're at. I'm pretty not published. I'm pretty sure they had to have Bortlen establish some piece of evidence. Yeah, listen. If y'all have not watched Bortlen's plea hearing, okay, please go watch it. I covered it. Law and Crime, Law and Crime covered it. Please go watch it. Because a lot of y'all are so misinformed. Because, thank you, Reax. If he has a no contest plea, he ain't even say he was there. So what pieces of evidence did he confirm? The state, we went over the actual document from the state and what they said. He hasn't even talked to them on the proffer yet. What did he confirm then? Like, I'm like, is anybody actually listening to what was on record? The state, and I'm not even talking about anything the defense said. The state said he agreed to proffer in the future, meaning it hasn't happened yet. The judge said, hey, whatever you work out later on with a proffer has no bearing on your plea. We're done here. Meaning, like, it's the proffer and the plea ain't even together. Y'all just got to listen. And I know a lot of people don't actually do trials. Obviously, a lot of the bloggers don't do trials. They like clips and they be so misinformed. I'm like, it's everything was said during the court. I know the whole narrative now is like, and I'll say this, because I know it's stuff like what the family said this, and let me tell you, right now we dealing with our own murder within our family, right? And you can ask probably 5 of us the same question, and we're gonna have a different version of what's going on. And this real. We all could be at the same meeting, okay? And 5 of us, maybe more, are gonna have a different version of what the people told us, how the people broke it down. On some real stuff. I done seen it happen already within my own family. So I would say this, just wait until it gets on record. Trust me, if Bortlen told, it's going to be confirmed through the court system, one way or the other. Whether the paperwork get requested and come out, whether at Melly hearing is put on, we're going to hear about it. So as far as me, y'all, I'm going to wait till that time happens. I'm not going off of what nobody's saying on it, because from what was said on the record by the state, he hasn't even talked to them yet. He agreed to sit down, and we don't even know. Again, we don't know what he's going to say when he do, if he does it. You know, so that's just that. But again, y'all know in our culture it's easy to say somebody snitching, but until like this case, we done already heard him say that he ain't even talked to him. Now, if it comes out that he is, then hell, we'll talk about it and be like, all right, boom. But like right now, it's just like we ain't even heard that yet. All right, so what else we got? I'll be in federal court tomorrow because, like I said, right now I am covering the man that we feel killed my cousin. Again, he hasn't been officially charged yet, so I have to say it like that. He'll be in federal court, and I'm going to his hearing tomorrow. So I may do content on him tomorrow. I don't know, but I'm going to his court for sure tomorrow. Y'all know, if y'all didn't catch my last live, I got in a wreck the day they found my cousin. So last Friday, I got in a wreck. So I have to go see the doctor tomorrow on that. So I'm gonna try my best to do some content, maybe later today. But it's been a lot going on, so. But I'll try my best to get something done. It's gonna be a busy tomorrow. Definitely gonna be busy. How do you think the appeal court would rule chance of throwing all warrants out if they were flawed? I mean, me personally, I would think they would just withhold Judge Murphy's ruling. But just rewind a little bit, because I already said it, but I'll briefly say it again quickly. I don't feel like the state ever really gave a damn about the warrants. I think it was a ploy to get more time. But what y'all said her name, Buckaloo, for Buckaloo to do what she got to do. When her time was denied, then all of a sudden they needed the warrants back. So that's just my little 1-2 about it. I think it's all a ploy. But all right, y'all, I need to get up out of here. I do appreciate y'all for pulling up. Sorry for the bootlegness, okay? But we got the audio done, okay? Y'all make sure y'all rewind for those who was not here in the beginning. I will clip it down and make it a video and momentarily. And boom, there go I'm right on time. My alarm just went off. So y'all like, comment, share, subscribe. Tell a friend to pull up on your girl, Make the Truth. I'll holler at y'all.